Nteza Zulaika is my name. I'm a Deputy Registrar in charge of the ADR Registry. The Alternative Dispute Resolution Registry was created by the judiciary to coordinate alternative mechanisms that have been put in place alongside the ordinary hearing or trial system that is known to the public. These are mechanisms that are going to help us as an institution to be able to deal with the backlog and the workload that we have in the judiciary. The ADR mechanisms include mediation and plea bargaining. I'll talk about each one of them separately. I'm going to start with mediation. Mediation is an ADR mechanism where a third party sits with the parties who have a dispute to help them see their dispute in a bigger perspective, but also to support them to be able to reach an understanding. Right now, judiciary is running a pilot program of court annexed mediation, where parties who have filed cases in court are referred to a neutral third party to support them to resolve their dispute instead of going into litigation. We have discovered that as an institution that it is not possible for us to only deal with litigation or hearings, but also we need alternative mechanisms to support people to deal with resolution of disputes. ADR is one of the most preferred modes of resolving a dispute because it is cheaper, it is faster, and engaging to the disputants. Through the use of ADR, the parties propose a resolution to their dispute. At the end of the day, what they have agreed on becomes the judgment of court. So we want to call upon the parties to embrace mediation and then plea bargaining in the criminal matters, because mediation only caters for the civil and land matters together with family to help them resolve their disputes. In mediation, when you file a matter in court, you are referred to a neutral third party who is a mediator, and we have court annexed mediators throughout most of the courts in the country. Some don't have yet, but we're yet to have them deployed. So when you ask the judicial officer to refer you for mediation, or if they have referred you for mediation and you are interested, since now it is not compulsory, that third party sits down with the disputing parties to support them to resolve their dispute. A lot of people have had matters in court, and the outcry is that cases take long, and also the fact that they stay long in court, they end up spending a lot of money on litigation. So the judiciary has put in place a mechanism or mechanisms to help them deal with disputes that have come to court within a short period of time, but also to be able to spend less money while resolving those disputes. There are so many advantages that we can speak about ADR. The first and most important one is the parties themselves suggest or propose a resolution to their dispute. There is nothing as good as giving people a justice or a justice system that they love, that they participate in, that gives them what they ultimately need. So many times as judicial officers, we have been hearing cases and making judgments, and the parties appeal against those judgments. It has been worse where even the successful party chooses to appeal against the judgment of court. For instance, where a lady comes to court and she says, my husband has been beating me, I want him to be imprisoned, he has been torturing me for a long time, and then a judicial officer goes ahead and sentences him to 5 years of imprisonment due to domestic violence. Sometimes we have seen them appealing and saying that the sentence that has been passed against my husband is very harsh. They have come back and said they don't have food to feed the children at home. And yet we find that if, for instance, we had engaged her throughout the trial to exactly know what she needed, we can be able to give her that kind and quality of justice that she desires. So we are using mediation to help the parties participate in decision making. And also we have been able to track the progress of the program to know and to understand that decisions that are made through mediation are more everlasting. They give people a solution that is permanent, because none of them will be willing to go and appeal against it since they have participated in the decision making. So I want to call upon the people of the Republic of Uganda to embrace mediation. We are currently running mediation in most all the High Court divisions. We are running it at the Chief Magistrates Court, but also at the Grade 1 court level. Another beautiful thing is that we're also doing appellant mediation in the judiciary of Uganda. We have mediation at the Court of Appeal, and very soon it's going to be introduced in the Supreme Court. People thought that where a judgment of court is in existence, the parties cannot sit down to resolve a dispute. In Uganda, it has been tested and applied, and it is possible, because most of the matters which are in Court of Appeal are appealing against decisions that have been issued or granted at the High Court level. So when they come to Court of Appeal, the justices there sit down with them and see which matters can be resolved through mediation, and it has worked. I wish to inform the public out there to know and understand that these innovations that the judiciary brings on board have been researched, they have been applied, and they have been tested and found to be very relevant in today's world, and also very beneficial to the court users. So I want to encourage them to use those avenues to resolve their disputes. There is nothing that is as bad as coming to litigation and you lose all the resources that you have and you waste all the property that you have earned because you are litigating over a matter which you are not sure how it is going to end. When you participate in a decision making, you know what the outcomes of the case is going to be, and they will actually give you that exactly that you have agreed on, unless if the judicial officer finds that you have agreed on something that is against the law or something that cannot be enforced by the law or within the law. But otherwise, when you agree on something, that is what the judicial officer takes, and it is what they give you as a judgment of court.